Ready? Start. Now, what we have to consider is whether all the relevant facts necessary for deciding the additional ground of appeal were on record or the case required further investigation into the facts. Stop. The learned counsel has drawn our attention to page 6 of the assessment order where income from business was computed and after allowing benefit of brought forward loss of rupees 2 lakh, net income was computed at rupees 24 lakh. Stop. He further drew our attention to page 6 of the assessment order where 30% of the book profit under section 115J was computed on which tax was charged. Stop. Thus, it is obvious that all the relevant facts for admission of the first additional ground of appeal are already on record, and the same does not require any investigation into the facts. Stop. Therefore, the first additional ground raised by the assessee arises from the facts which are already on record and which do not require any further investigation, and also the same is purely a legal ground. Stop. Accordingly, by relying on the judgment of Honorable Supreme Court in the case of National Thermal Power Corporation Limited, we are of the considered opinion that the first additional ground relating to benefit of carried forward loss deserves to be admitted even though such ground was not raised before the authorities below. Stop. In the light of these facts, we reject the objections raised by the learned departmental representative and admit the first additional ground. Stop para. In this regard, we wish to mention that provisions of section 115J were introduced in the statute whereby a company was made liable to pay tax on at least 30% of its book profit as shown in its account to be prepared in accordance with schedule of the Companies Act. Stop. For this purpose, the assessing officer is first required to compute the income or loss as per normal provisions of the Income Tax Act. Stop. For the purpose of arriving at the total taxable income under the normal provisions of the Act, the brought forward loss and unabsorbed depreciation has to be given set off, and if any such business loss remained to be carried forward, the same alone is allowed to be carried forward irrespective of the book profit computed under section 115J. Stop. The very object of the provisions of section 115J is to tax such companies which are making huge profit and also declaring substantial dividends. Stop.